Welcome to Off the Record, a legal podcast.
Hello and welcome to Off the Record, a legal podcast with attorney Rhett Burney. With years of experience in family law, personal injury cases, and estate planning services, Rhett and his team are well-versed in providing top-tier legal representation for individuals across the state of South Carolina. I'm your host, Kevin Rosenquist, and today we're going to talk about navigating post-divorce modifications. Rhett, good to see you again. It's been a minute.
Yes, Kevin, how are you?
I'm doing great. I'm happy to talk to you again. It's always fun chatting with you.
Absolutely.
So what are the legal standards that need to be met in order to qualify for a post-divorce modification in South Carolina?
Yeah, so post-divorce modification, that means people have already been divorced, there's already a court order, and people are wanting to change what that order says. So in South Carolina, anything involving property, you can't go back and change it. If alimony has been barred, you can't go back and change it. But typically what we're dealing with are those cases where alimony was ordered previously, or in any case involving a child or children, you can go back in and change custody, child support, visitation. With alimony, you can change the amount, stop it if you need to, modify it. But what you have to show as someone that's maybe wanting to change the court order, you have to show a substantial change, material change in circumstances to warrant going back to court and asking the court to allow you to modify that previous order.
And what kind of changes are we looking at here? I mean, financial, age of the kids. Can you kind of talk about the different things that would impact a modification?
We usually see in the typical modification cases, we'll just say child support, for instance, or alimony, for instance. There may be a substantial change in one of the parties' incomes. Someone may have lost their job through no fault of their own. They may have retired. That would be a substantial change when we're looking at the financial realm. A little bit deeper when we're looking at children. Your child support may change, where at one time you may have been paying for 3 children and now one child has emancipated. So that may call us to, of course, go back to court to get that modified. Or, one of the hardest cases are we're talking about actually changing the custody and the visitation of a previous court order in regards to children. And so that may look like, the easy ones where a parent gets addicted to drugs or something like that. What we're seeing more and more with people moving around is parents are wanting to move from one state to the other. And when that happens, then one of the other parents, the visiting parent, their visitation is going to be cut down. So that's usually what we see in the modification. Sometimes parents just don't want to take care of the kids, or they can't handle the children. The children aren't going to school, or the children are doing poorly in school. And we try to focus in and see why that's happening. And that may give us a good enough reason to go back and modify a previous court order.
You mentioned before someone losing their job through no fault of their own. What does it matter if they just quit because they get mad at their boss? Like, does that change the way that the court looks at the situation?
Yeah, and inevitably, we always hear, well, if I've got to pay child support or alimony, I'm just going to quit my job. Yeah, the way the law is written is you can't do that, because the court you can quit, do whatever you want to do, not go back to work. But the court will look at the fact that you were capable of making a certain amount of money, and they will impute to you, meaning that they will say, we're going to calculate child support based upon what you were able to make, even though you did quit your job voluntarily. And so just deciding you're no longer going to work to lower your income so you don't have to pay alimony or child support, that doesn't get you out of it. You have to have, but if you lose your job because they terminate you because they're doing away with that position, or your company shuts down, then that's a good reason why you would go back to court and have alimony or child support modified.
Do they look at them differently? I mean, will they cut the alimony before the child support if both are happening? Is that how that works?
So maybe. So let's say that you have a loss of job, or your income's reduced through no fault of your own. Child support, what someone is paying in alimony, that is a factor that goes into what someone's child support will be. So they kind of work hand in hand. So yes, it will affect both of them in some form or fashion. If you go back to get a modification and they don't modify your alimony, you still may have your child support modified because you have a reduction in that income. So just because you're lowering one doesn't mean that both of them will get lowered, but usually the facts will support the reason as to why you're wanting to get it lowered. And that's probably because you've had some reduction or maybe even an increase in your income to cause there to be a change.
When talking about a change in custody or change in visitation, you mentioned one obvious one would be the parent gets addicted to drugs or something like that. What does the court take into consideration? Maybe that's an extreme example, but are there other situations where, that someone might request a change in custody or visitation, and what does the court typically look for?
Yeah. So what we hear in the second case, let's say, lots of times, if it's not an easy one where somebody's been arrested for murder or addicted to drugs or what have you, it's typically the children or child doing poorly in school, not going to school enough. The other parent is out doing things other than being home parenting. Those are the classic examples that we have. Or you may just have a child get to a certain age, they no longer want to live with that parent. Maybe the personalities conflict, right? You have males that have been with their mothers, they've gotten older, they want to go live with the dad. And parents have to say, are we going to fight this child, or is it something that we may try for them?
Yeah, I've known people that have done that, like in their high school years. Their parents got divorced at a young age, but in their high school years they swap because they're just butting heads. So, teenage daughters and moms don't always get along, and like stuff like that. So, I definitely have heard that happening before.
Yeah, that happens. And then we also have those cases where you have the parent who doesn't have, original custody of a child. They just happen to have a lake house. So they just happen to buy a new puppy, and they just happen to buy the kid a car. Now the child wants to move over there. Well, is that in the best interest of the child? That's right. What they look at. And sometimes it is, sometimes it's not.
Yeah, I mean, it depends on how cute the puppy is, I suppose.
Exactly. How nice the car is. Yeah.
Yeah. Or how nice the car is. Yeah. What kind of car was it? So when it comes to, you mentioned relocation before, a lot of states seem to have they take that differently. Some are a little bit more lax on letting people relocate. Some are really strict about it. How does South Carolina handle modifications, when one parent wants to relocate and maybe the other one is hesitant, or what things do they look at?
Relocation cases are very, very tough cases. I'd love to tell you that the law says a certain thing, and it does. There are factors that the court is supposed to look at when considering whether or not to allow a parent to move with a child. But every judge has their own likes and dislikes. So you can have the same set of facts, go in front of 4 different judges, 5 different judges, and get 4 or 5 different answers. The law is clear in what the court's supposed to consider, but that doesn't always mean that the judge is going to follow what the law says. The first thing the court's supposed to look at is, why is this parent relocating? Did they just want to move to the beach because they like living on the beach? Or did their job, did they get transferred? Or are they getting remarried and that's where their new spouse lives? Or maybe they need, their support system is in a certain place. So if you're going to move with your children, you better have a good reason to do it. It just can't be because you want to try a different lifestyle or live in a different part of the country. You need a good reason. And usually it's going to be, do you have a good financial reason that you need to move?
But even if there is a good reason and the other parent is fighting it, does not want it to happen because they know they're going to not going to be able to see their kid nearly as much. How does the court typically handle that sort of battle?
Yeah, and it's hard. It's hard. The court's then going to need to look at, what was the relationship like with this visiting parent? What type of relationship do they have with the child? Is it a close relationship, or is it just very? The parent just shows up every now and then. That's why it's so hard. We have certain factors we're supposed to look at, but then you have the facts behind everything. And when we start looking at that, you may have a very involved father. Let's say the mother has custody of the child and the father's always the baseball coach, always the soccer coach. He knows math, so he's teaching his child all these. He's tutoring the child and doing those types of things. They're just very, very involved, and they have a very, very close bond. Do you separate that? I mean, there's no problem if you want to move without your child. The court could care less about that. But are you going to take your child away from that great relationship they have with that other parent? And is that going to be more detrimental to the child? Those are the types of things that the court has to listen to and you have to put forth. So there's never a black and white case. I mean, it's very hard. And as lawyers, when we get the relocation cases, they're the kind of nuclear bombs of the family court because of what happens. If one parent moves and it's a long distance away, when does the child get to see them? How much is it going to cost? Are they old enough to fly? Are you going to be driving? How often is that going to be? Because Kevin, you've got kids, right? Can you imagine just seeing your children every summer? What type of relationship do you have at that point in time?
That'd be hard.
It's not going to be very good.
Yeah.
And it gets costly. If you had to fly to North Carolina, I don't know where you're out in Colorado. If your wife moved here to South Carolina, you do that once a month. That gets expensive.
It's very hard.
Yeah. It's very hard to do. The regular person can't do it. So that's why those cases are so serious because of what it does. It separates children from their parents, and it adds a lot of expense to that parent who wants to see their child more than they may be ordered by the court.
Is there a certain distance that the court doesn't care about? Like, is there a threshold? Is there a rule? Like, oh, well, if it's only X amount of miles, then it's fine. If it's more than that, we have to talk about it. Or is it just strictly case by case?
Yeah, I mean, we have it in South Carolina, like 99 miles or something like that. But I mean, let's face it, you can still, if you're 2 hours away, where normally you were 5 minutes away, the court is still going to take notice as to why you're moving.
Right.
So there's no magic distance in that regard. Supposedly there is, but the court doesn't always listen to that. Because where we live in South Carolina, 20 minutes, you can be in another state. Or you can drive in the other direction 4 hours, you're still in the state of South Carolina. So the distance doesn't always matter, or the states don't matter. It's really the distance and the logistics of it.
Yeah, and depending on where you are, if the city gets more crowded, if they're just getting around is harder, traffic gets worse, whatever, like it can, just because it's only 10 miles away doesn't mean that it doesn't make a huge difference depending on where you are in the country.
Right. Yeah. So it's just tough. And those types of cases are getting more and more prevalent because people are moving. Their jobs are elsewhere. And we didn't used to be as transient as we are now, but we're seeing an uptick in those relocation cases because people lose jobs and they go get jobs elsewhere. So right. It happens. It happens.
What is the process for requesting a modification? Do you have to go to court for any time you want to have a modification?
Yeah, unless the parties are able to agree outside of court. If they have a good relationship, some people do. Most of the time, that's not the case. So, one of the things we have to address as lawyers is, does that moving parent tell the other parent they're going to move? Sometimes the previous order says they have to. I always think it's just fair to tell the other parent, hey, these are my plans. You don't want to do it by surprise. I have that happen. Sometimes people want to surprise the other parent. I think that just looks bad, right? And I think that's just in bad taste. I think as soon as you find out that you're going to move or you want to move or need to move, you need to reach out to the other parent. There may be a great solution. I've had the visiting parent say, you know what, that's great. I'm moving too. It's not feasible for everybody, but some people have those type of jobs. They can work anywhere. So I always preach to my clients or those people who come in and want to know the steps. I think as soon as you know that you may be moving, go ahead and start that discussion. If you don't, great, you've had the discussion. But if you do, that way the other side can't say that you just threw that upon them and surprised.
Are there any specific pitfalls that you think individuals should be aware of, when seeking a post-divorce modification? Yeah,
make sure that you can prove your case. Make sure you tell your lawyer everything. It is not uncommon for us as lawyers only to get the good side of everything from our client. And I don't know why, maybe it's human nature at this point, I kind of think, they don't tell us everything. And so we get in front of a judge on a temporary hearing at a modification, and we're saying this has changed. And then they don't tell us the bad things. And the other side has all this ammunition and, they kill the case right there from the very beginning. So, if you are thinking about, or you may need a modification of case, go talk to your lawyer, and just ask them, tell them everything. This is why I've lost my job. That's why I need child support to be modified. That's why I need alimony to be modified. Don't tell them that you lost your job, but it was because you never showed up for work, right? The lawyer's going to give you different advice. And our advice is only as good as the facts that are presented to us. And it's not uncommon at all in the world that we live in that we not get all the facts from clients. Mm-hmm. So be honest with your lawyer.
Yeah, that's something that I think we've talked about before is like the lack of transparency from clients can sometimes, it makes it hard for you to do your job properly.
You can't do your job. And there's nothing worse as a lawyer being in front of a judge in a trial and finding out some very, very crucial facts at a point in time where there's nothing we can do about it. And, we don't pay the price. It's the client that pays the price ultimately. So we're only as good as the information that is given to us. And if you don't give us the right stuff, we can't do our job.
And what is the process for contesting a post-divorce modification?
Yeah. So what's going to happen if somebody brings a modification case? You're going to have a hearing, a temporary hearing. And if you're opposing that, you come in and you say why this is, as I stated, if it's a custody visitation, you build up the relationship that you had. You show this to the judge, the relationship you had with the child. Why you may want custody. That's one of the best defenses, right? Going off and say, well, if you're going to move, perfect. You can go ahead and move, but I want custody of our child. And here's why I should have custody. And here's what I can provide for the child. So that's typically what I do when I'm the person who is being sued. If the other side wants to move, I ask for custody. Let's go on offense a little bit. Let's see if we can get out.
Yeah, that's a good, that makes sense. That's a good time to do that, obviously. All right. Well, thanks for tuning in to Off the Record, a legal podcast with attorney Rhett Burney. For more information or to connect with Rhett and his team, you can visit rhettburney.com. And please like and subscribe to our channel. Leave us a review. Always good chatting with you. Thanks so much for your time.
All right, Kevin. Good to see you. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.